Croydon London Borough Council, Appellant, and Kalonga, Respondent.
This appeal is about the steps which a landlord needs to take to bring to an end a fixed-term secure tenancy before the end of the fixed term, under the regime now found in the Housing Act 1985, which gives security of tenure to residential tenants of public sector landlords. Before the secured tenancy regime came into force, tenants of public sector landlords occupied their homes under two main types of tenancy agreement. The first is what is called a periodic tenancy, which can be terminated by the landlord giving a short period of written notice. This type conferred no legal security of tenure upon the tenant, although in practice public sector landlords did not terminate their tenancies other than for some good reason. The second is a fixed-term tenancy for a specified period of years. This did confer security of tenure upon the tenant under the general law, subject to two typical contractual exceptions. The first was a break clause, which could entitle the landlord to terminate early, often on some specified grounds, such as a desire to redevelop the property. The second was a forfeiture clause, which enables the landlord to terminate the tenancy due to breach of its terms by the tenant. But forfeiture is subject to statutory rules about giving the tenant notice of the breach under the Law of Property Act 1925, and to the important power of the court to grant relief from forfeiture if the tenant remedied the breach. The main purpose of the relevant parts of the 1985 Act was to enshrine in law the de facto security of periodic tenants of public sector landlords by providing that a secure tenancy, as it was called, granted by a public sector landlord could only be brought to an end and the tenant evicted on the specified statutory grounds and by an application to the court for that purpose. But the Act had to fit fixed-term tenancies within its framework as well. It did so by providing that the fixed-term tenancy could also be brought to an end on the statutory grounds and possession of the property obtained by the landlord if the fixed term had either ended or if the tenancy was, quotes, subject to termination by the landlord, end of quote. The underlying question raised by this appeal is whether this statutory formula preserved the tenant's security constituted by her fixed-term tenancy while adding to it when the fixed term ended, or whether it entirely replaced that common law fixed-term security by the statutory scheme of security subject to the statutory grounds for possession. The Appellant Croydon Borough Council granted the Respondent, Miss Kalonga, a secure tenancy of 61 The Crescent, Croydon, for a fixed term of 5 years from the 25th of May 2015. The tenancy agreement entitled the Council to terminate the tenancy at any time if Miss Kalonga committed a breach of its terms, and also if any of the other grounds for possession set out in the 1985 Act applied. In August 2017, the Council sought to terminate the tenancy on the grounds of non-payment of rent and antisocial behaviour by Miss Kalonga, but it did not seek to exercise a right of forfeiture. Rather, it just sought to use the machinery for obtaining possession set out in the 1985 Act. Miss Kalonga asserted in her defence that her fixed-term tenancy could not be terminated early without it being forfeited, and that her tenancy agreement did not even contain a forfeiture clause. These 2 points were directed to be tried as preliminary issues, and were heard by Mrs. Justice Tipples in April 2020. In May, Ms. Kalonga's fixed term ran out, but in June 2020, the judge ruled that, since it contained no forfeiture clause, her tenancy could not be terminated early, as the Council had sought to do. If it had contained a forfeiture clause, then in the judge's view, it would have been subject to termination by the landlord, and could have been terminated early by using the machinery in the Act, without having to be made the subject of a forfeiture claim. The Court of Appeal dismissed the Council's appeal, both because the tenancy agreement did not contain a forfeiture clause, but mainly because, even if it had, a fixed-term secure tenancy could only be terminated early by forfeiture, which the Council had not tried to do. The Council appealed to the Supreme Court. Although Ms. Kalonga's fixed term had long since ended, the underlying point is of considerable importance for landlords and tenants under secure tenancies, so the appeal has continued in order for this court to rule upon it. The court unanimously allows the Council's appeal, but only in part. I give the lead judgment with which Lady Arden, Lord Kitchen, Lord Leggett and Lord Stevens all agree. We have decided that a secure fixed-term tenancy is not subject to termination under the Act unless some contractual right of the landlord to terminate early, whether by break clause or forfeiture, has become exercisable and is actually implemented. Our reasons are in summary as follows. Although the 1985 Act provides a measure of security of tenure, it may in many cases be much less than that provided contractually under the Tenancy Agreement by the grant of a fixed term. Thus, a fixed-term tenancy without a break clause could only be terminated early by forfeiture, and a fixed term with neither a break clause nor a forfeiture clause could not be terminated early at all. And a 5-year fixed term with a break clause at, let's say, the end of year 3 could not be broken earlier than then. By contrast, the grounds for possession under the 1985 Act include, for example, a right to seek possession where the landlord wishes to redevelop at any time, and the default grounds for possession do not accommodate the right to seek relief from forfeiture. We do not consider it was any part of the purpose of the 1985 Act to take away such contractual rights to security as fixed-term tenants already enjoyed. Our interpretation of the critical provisions of the 1985 Act, and in particular the requirement that a fixed term be subject to termination by the landlord before being capable of being brought to an end under the Act, gives full effect to that conclusion. By contrast, the decision of the Court of Appeal that a secure fixed-term tenancy could only be terminated early by forfeiture went too far, because it would deprive the landlord of the right to terminate early by the exercise of a break clause in the tenancy agreement. We have also disagreed with both the judge and the Court of Appeal in our conclusion that Miss Kalonga's tenancy agreement did contain a forfeiture clause. True it is that it did not use the word forfeiture or contain a typically worded forfeiture clause, but it did clearly provide for early termination if she committed a breach of the terms of her tenancy, and that is what, in substance, a forfeiture clause is. Whether a tenancy agreement contains a provision for forfeiture is a matter of substance and not form. If it were otherwise, the tenant's right to come to court for relief from forfeiture could all too easily be evaded by clever wording. In Miss Kalonga's case, however, the provision for forfeiture in her tenancy agreement was not implemented by the Council, so that both the judge and the Court of Appeal were right to dismiss the Council's claim for possession. Court is adjourned.